Okay, so this is going to be the beginning of the first primer to workers' compensation claim, and it's sort of the basics of how someone gets a workers' compensation claim. So it, it's important to note that today's date is January 10th, 2016, and workers' comp is in constant flux. Uh, and the way in which a person files a workers' compensation claim in the state of California may change over time because there are differences between the states. So there are two types of injury that a worker can have. One is called specific injury. So a specific injury is I'm at work, I'm lifting a box full of something, and I feel a pull in my back and pain. That is a specific injury. The second one is I've been working on this computer typing for 8 years, and my hands just are killing me. I have tingling sensations. I can't fully grip things. That's called a cumulative trauma because it happens over a time period. So what will happen is that somebody will have a specific injury, or they'll discover that they have a cumulative trauma either through their doctor or they recognize it themselves. And they'll go to their employer and say, hey, you know what? I've been hurt, and I think it's job related. I was picking up those boxes of oranges, and I felt something go pop in my back, and I can't stand up straight. I'm having pain. It is the employer's responsibility at that point to hand the applicant a DWC-1. And there should be a package with this video which shows you what a DWC-1 is, and it comes in English and then in Spanish. The employee's job is to fill it out, the top part, hand it back to the employer, and within 24 hours or the next business day, the employer is supposed to fill it out and give a copy to the applicant either by mail or personal delivery. This sometimes can be avoided if it's only a first aid thing. Hey, I cut my finger and I need a Band-Aid. Well, we don't need to go through all the formalities of a workers' comp claim to record that on DWC-1. However, something more major than first aid needs a claims form. Then, once the claims form is done, it's sent off to the insurance company. The insurance company's job is to set aside $10,000 for medical care, while determining whether or not they'll accept the claim. The employer will then or not then, but at some point in time, hopefully prior to the insurance company setting aside the $10,000, send the applicant to the industrial health care facility. And it's workers' comp is a filthy business to be in some respects, and that is that the medicine that they do is doctors on one side of the forum treat people just enough to get them back into work, and sometimes not even that much. And on the other side of the forum, the person with a relatively recoverable injury will never make it back into the workforce because the treating doctor can treat them forever. So it's something you'll see as you work for my law office that we try to balance out. And I think everybody has their own balancing understanding, but I think we all sit there and say, you hurt your shoulder, you had a rotator cuff tear, it's been 6 months since the surgery, go back to work, or whatever the case may be. So they give they go to the industrial health care. The industrial health care, if they can take care of it and they don't feel neglected, then they'll never hear from me. They'll never seek me out. But usually what happens is they've determined that they've been hurt a lot more than what the industrial doctor is trying to put off on them, and they'll go out and seek another doctor or a lawyer, and then we send them, if they're not already sent, to better doctors, quite frankly, non-industrial doctors. Now, I'm not talking about the quality of medical care that a doctor can give. I'm talking about the willingness of that doctor to give that quality of care. And we'll go into that a little bit more detail later. So if the doctor decides that the applicant cannot go back to work, or that they can have to go back to work with limited duties, for example, I tore my rotator cuff and my arm, then obviously we don't want them lifting with that arm. And if they are lifting, it's going to be something that they can endure. And if they take them off work completely, that's called temporary total disabled, and we refer that to as TTD. If they are taken off of work with or given work restrictions, we call that totally partially disabled. And what will happen is the partially disabled applicant has to go back to their employer and say, here are my restrictions. It doesn't matter if the employee says, I can't do those restrictions. They have to go back and attempt those restrictions. If they go back and they experience pain under those restrictions, they should stop immediately, inform their employer, and be sent back to the doctor for the doctor to hear them and understand what happened. Without doing that, without somebody who's temporary partially disabled, TPD, if they just decide not to go back to work, I cannot go into a court of law and fight for them, because the judge is going to go, well, I'm not going to award temporary partial disability payments because they could go and do some meaningful work. And that's sort of, there's an underlying current, even the psychologists even claim that if you have somebody who is out of work, it's important to get them back into work. When you have someone who calls the office and says, hey, I'm not getting any TTD, you need to go through a couple of understandings of that claim, and we'll get into that more later. I don't want to get too far off track. So they'll either be on TTD or TPD, and if they're not on either, they can go on state disability insurance, which is from the state for 1 year, and that's through the EDD department. The EDD, Employment Development Division, has two departments that I'm aware of. One is unemployment insurance, the other one is state disability insurance. And after the 1 year, they will they'll quit paying, and the insurer is supposed to pay. Sometimes you have an injury that lasts for 3 years. Well, the insurer is responsible for the first 2 years of TTD or TPD if no accommodations are made. If they don't pay for those first 2 years, what they'll do is they'll refund SDI the money that they were supposed to spend in the first year and pay the applicant the next year. The applicant should, after the second year, say we're going on to the third year now, they should go back to EDD, SDI, and apply under the same number, because that, well, we call it a basket. That basket of funds has been refilled. But if they refile anew, they'll get a different rate than if they just refile under the old claim. And I don't do SDI law. I don't know how to get paid for it. I don't understand the law. So if somebody says, can you help me with my SDI? The answer is no, we don't help them. And I believe it's relatively simple. This includes both illegal people, illegal aliens, and legal aliens. So what will happen is they'll go through their duration of treatment, and they'll be getting every 45 days they have to see the doctor, and every 45 days we have to receive a report saying whether they're TTD or TTD or they're permanent stationary or reach their some medical improvement. And what that is the um, the doctor will decide that the person has reached their maximum medical improvement, meaning that they are not 100%, but they've reached their new 100% or as healthy as they're going to be with regards to their workers' comp claim injuries. Uh, so then you go to
Daddy,
yeah.
Mom is talking to you.
Yeah, I